Good evening, everybody. This is Paul Godfrey. I am a Florida attorney. My opinions are my own. This is not legal or investment advice. This is for educational purposes, and hopefully you find it entertaining as well. This is my second video on the Ripple case, and we're just going to go ahead and move along. The first thing that I'm going to do is address some of the comments I got. More than one person pointed out that I didn't really provide a lot of information. Basically said I didn't do much. Well, these cases are slow moving, so this is going to happen like that just because if I cover everything at once, it would be a 3-hour long, 5-hour, 8-hour long video, and then you'd have to wait another 4 months for the next thing to happen. So I'm trying to chop it up piece by piece. Again, the first case was filed June 5th, 2018. Let's see if I can find that. That is right there. You see, June 5th. And that was 1 year and 3 months ago. And now where we're at in the current case is we're only at an amended complaint, and that amended complaint itself is 53 pages. So in my last video, in about a 10-minute period, I summarized technically 4 cases, 3 in state court and then 1 removed to federal court, over a 15-month period in about 10 minutes. And so that's not too bad as far as summaries go. And I'm telling you this for 2 reasons. 1, like I said, I think that's half decent for a 10-minute summary. And then 2, again, we're just getting started on this case. We only have the plaintiff's pleading. We don't even have a response to the pleading, which would be a motion of some sort, as opposed to an actual responsive pleading, which would be an answer. So again, this case is going to span for quite some time. It's been over 15 months, and we are just getting started. So if I have your patience, I appreciate it greatly. Next up, something else I want to start with is going through case updates. Again, I check the docket every week, and most recently what has happened, we have got some notice of appearances, well, a notice of appearance, and it was actually for Ripple Labs and Mr. Garlinghouse, and the lady attorney who is representing them she's quite the hard hitter. She went to Harvard both for undergrad and law school. She was a clerk for Supreme Court Justice Stevens, the late Justice Stevens, who passed away in 2016. She worked under the Obama administration and the federal government. She knows what she's doing. To say she's a good attorney is an understatement. So Mr. Garlinghouse and Ripple Labs have lawyered up. Let's put it that way. If not already, even more so. So that is enough of that. Next up, let's go ahead and get into legal writing a bit and the amended complaint. So I'm going to give you a brief summary overview of the amended complaint as it's progressing right now. So we pull up the amended complaint, and you see here is the table of contents. It's nice, short, succinct, 1 page long, pages 2 through 50. The whole document is 53 pages. So first, I'm going to go into what we call your basic legal writing skills, because I want to try to help you analyze this case from your own perspective. I'm not going to give you my opinion. I'm going to hopefully give you the tools to help you form your own opinion. What we learned in law school, or what I learned in high school, the legal writing method is called IRAC or CRAC. It's IRAC or CRAC. CRAC is sometimes called crack, haha, joke. It means issue, rule, analysis, conclusion. Generally speaking, the way motions go is you've got 3 sections. You've got a facts section, which is pages 2 through 43 here. Then you've got your argument section, and then you've got your conclusion. And in the arguments section is where you get your IRAC analysis: issue, rule, analysis, conclusion. So the issue is, this is more for motion practice, motions for summary judgment, trial briefs, motions to dismiss, etc. But that same pattern: issue, rule, analysis, conclusion, pretty much dominates the legal writing field as you know it. So I'm going to go over a bit about legal writing. Facts, we're not even going to touch facts for a bit. I'm going to go over the causes of action and then later there are remedies. Remedies will probably be my next video. But right now I just want to explain legal writing to you generally and then briefly touch on the causes of action, because each one of these causes of action in themselves can take, each one of these causes of action could have a whole hour-long law school course on them, if not more. So again, trying to keep this video brief to about 10-15 minutes. So summarize, issue, rule, analysis, conclusion is your basic argument style, and most legal writings are divided into three parts. You have your facts first, then you have your argument, it states what's the issue. Okay, this is the issue. And then you go R, what's the rule? All right, this is the rule for this issue. A is analysis. So what's analysis mean? It's where we take the rule and then we apply the facts to the rule, or more appropriately, apply the rule to the facts. The rule is the rule, and it does not change. The facts change, but the rule does not. And then based on our analysis of the fact pattern under the rule, then we come to our conclusion. So what I'm going to try to help you do is teach you the rule and learn how to formulate this on your own. Some people have already commented, well, it's not a security. Well, if you've come to that conclusion, you don't really have to watch these videos. I'm not going to be of much help for you. Some people argue it is a security. Again, if you've come to that conclusion, that's great. Happy for you. Again, I'm not going to be much help for you. If you want to be able to analyze this stuff on your own, that's kind of what I'm here to help you do. So I'm going to first touch on the causes of action, go over them very quickly. Then the next video will probably be on remedies, and then I'm going to actually need your help on the facts, because there are just so many facts. There's one of the things of which we're informed in law school is even in one page of a document, there can be roughly over 700 distinct facts in just one page of legal writing, and it appears that in the federal California courts they use the extended 14-inch papers, as I can see them right here, so even more than that. So let's go down to the causes of action. We have 7 causes of action. There are 2 federal claims and 5 state claims. And number 1, the hard-hitting one, is 7th claim for relief, 6th claim for relief, 5th claim for relief, 3rd. Here we go, causes of action. So the first one, everybody knows it, unregistered offer and sale of securities in violation of Section 5 and 12A1 of the Securities Act. And this is against all the defendants. Remember, not only did we summarize the court cases, we went over who the defendants are in each case. So not every cause of action is against every defendant, as we will see. So the first one is it was or is Ripple. They are being accused allegedly of offering and selling unregistered securities in violation of the Securities Act. The second cause of action, a violation of Section 15 of the Securities Act. Again, I will get into more detail on these later on in the video, but this is only against the control person defendants. The control person defendants in this are Ripple Labs and Mr. Bradley Garlinghouse. So here, the second claim of relief is only against 2 entities or individuals, persons. Some people believe corporations aren't persons, but for purposes of the law, corporations are people. So you have the defendant, Ripple Labs Incorporated, and Brad Garlinghouse. Together, they are the control person defendants, and the second cause of action is against them. And then you have causes of action 3 through 7. And these are all California codes. So under 3, unregistered offer of sale and securities of the California Corporations Code. 4, and that's very similar to, there's nuanced differences. Also an extra test, and I'll get more of that later. But anyway, that's different than the federal securities violations, potentially. 4th, another state one is violation of Section 25401 of the California Corporations Code against all defendants. 3 was against all defendants as well. The 5th cause of action is violations of these sections of the California Corporations Code. And this is against the control person defendants. Again, this is just against Ripple Labs and just against Mr. Garlinghouse. Then you've got the 6th cause of action. This is against all defendants. False advertising, violation of California codes. And then we've got the seventh cause of action, unfair competition against all defendants. So not every cause of action is against all the defendants. It's certain plaintiffs against certain defendants depending on what the cause of action is. And then lastly, we have our prayer for relief. And this is where, okay, so say you allege a cause of action and the court says, yeah, they did that. Well, there's an old expression saying your rights are only good as your remedies. So you may have a right, but your remedy is how you are compensated, or how you get to enforce your rights. If you have no remedies, then you have no rights. So what occurs in their prayer for relief is actually very important, and somebody brought that up in a tweet, and I will actually do a whole nother video on that later. I can see my time is almost running out, but again, to do a quick summary of everything again, there is the IRAC writing style. You don't see it so much here in the pleading. You'll see it as soon as we get some motion practice, and I'll show it to you. Again, you have your facts, which again, if you go here, we've got what, 2 through 43, so that's over 40 pages of facts. And then you've got these causes of action right here, and there are 7 of them, and basically what happens in these causes of action, they pull from separate facts that they cited throughout their factual sections. So the causes of action said this is the rule, and under the rule, based on fact here or fact from this section or fact from this section, they've basically harmed us or committed some sort of tort or breach of contract, or however, violations of the security codes. There's been some sort of wrong, and accordingly they either owe us money or they have to do something. Again, we'll get to relief and damages and equitable relief and declaratory relief, which isn't requested in this, all in later videos. But for now, right now we have the amended complaint. They have a big fact section. There are 7 causes of action, 2 federal claims, 5 state claims against varying defendants, and then they've got their request for relief. One thing I am going to ask your help with, as part of this, as we proceed through part of this, certain facts here, I've found certain allegations are actually incorrect. So if you want a copy of this, you by all means, send me a tweet. I'll figure out a way to email it to you. I've got no problem doing that. Go ahead, and I'm going to need help fact checking what facts are alleged here, because that's just going to take forever. So that being said, that's it for this video. This is Paul Godfrey. Be well and be kind to each other, and I hope you have a good night. Thank you.